Oh, well, thank you. There. So thank you. So I'm going to talk about those aspects of health and personal care that deal with consent capacity and substitute decision-making in Ontario. So first of all, like, why this subject? Well, a lot of people ask about substitute decision-making and consent and capacity without actually knowing even the terms. So like, this is an area that for a lot of people is actually quite important, because the healthcare system in reality is very rule bound. There are lots of laws and regulations, and we as regular John Q. publics just walk in and we're often blindsided by things. And so I'm basically going to try to provide some information. It's based on two relevant laws in particular, but there are other things that I've synthesized. I'm not a lawyer, but I've studied law, but you know, it was more things like trade law, other international law, and but I can use those skills to synthesize, and that's what I've tried to do here. I'll share some lived experiences with you, and I'll invite you to share your experiences as well. Now, the next slide is what I call learning outcomes. It's what I'm hoping to deliver. So a basic understanding of consent to health-related and other personal care. Second, the capacity to take health and personal care-related decisions. And third, substitute decision-making for health-related and other personal care incapable persons. So the two pieces of legislation that are key here in Ontario are the Healthcare Consent Act, which I abbreviate as HCCA, and the Substitute Decisions Act, SDA. And I'm focusing on Ontario because healthcare is a provincial jurisdiction. There are, however, some Supreme Court decisions that are relevant. If we go to the next slide, what I tried to do here is set out the scope of the two laws. So Healthcare Consent Act and Substitute Decisions Act. What I'm trying to illustrate here is that they function in parallel to one another, but there are differences between them, many differences, in fact, in the fine print of the laws. And if you look under SDA first, you'll see that personal care includes healthcare, nutrition, shelter, clothing, hygiene, and safety. And in many ways, that is an illustrative listing of what is meant under HCCA. So it starts to amplify it a bit. But one of the things that are said in the laws or in the government guides is that there are differences between them. And in some areas, if you have a complaint, you will file a complaint under the SDA instead of the HCCA, depending on what the specific complaint is. But HCCA covers healthcare and then long-term care. And you can imagine, like, long-term care includes healthcare, nutrition, shelter, clothing, hygiene, safety. And personal assistance services, as I understand it, is mainly things like home care, where you have somebody coming and providing personal assistance services to you, not in a long-term care setting. The next slide is going to provide a breakdown of what healthcare services mean in the law, in the HCCA. So what I'm doing is I'm starting with some general. So here are the two laws, and then here are the main headings underneath them. And I'm going to amplify what treatment means, healthcare treatments. I won't do the same for long-term care or personal assistance services because it was going to become too long and complex. And I think let's just deal with this right now. So, and definitions are always very important whenever you're dealing with laws. So the definition of treatment. Treatment means anything that is done for a therapeutic, preventive, palliative, diagnostic, cosmetic, or other health-related purpose. Okay, now that sounds fairly comprehensive, but back in 2013, there was a Supreme Court decision that dealt with this definition of treatment. There was a case in Toronto known as Rasouli, R-A-S-O-U-L-I. And that was a tragic case. There's a man who went and had an operation and he ended up in a coma. And the doctors wanted to disconnect him. They felt that he was in a persistent vegetative state and that keeping him connected was senseless. They wanted to disconnect him. And they felt they had the authority to do that without the consent of the man who was in a coma or his wife, who was substitute decision maker and who is trained as a medical doctor in Iran. There were lots of issues. So like if you look at that case, there were a lot of unpleasant issues that came out with this. The wife, she said, my husband is not in a persistent vegetative state. He's in a minimally conscious state. You can't do that. I can in effect communicate. He is able in some ways to respond, to let me know that he can hear what I'm saying. And the doctor said, we're going to disconnect him. If you don't like it, you can sue us. So she took them to court. She didn't, and the lawyers even didn't take it under the Healthcare Consent Act. They went under the Substitute Decisions Act, and they went through a different body of law, the SDA. And eventually the Supreme Court decision ruled you really should have done this under the HCCA Consent and Capacity Act. Now these things are merged together. So if you have a dispute under one or the other, they both go through the same body to be adjudicated. But the Supreme Court decision also said withdrawal counts as a treatment too. And the decision was written by the Chief Justice, and she said that withdrawal affects a patient's autonomy in the most fundamental way. In other words, it was going to kill him. And so for them to say, hey, we can do this, that didn't wash. You have to have the consent. Now, it's useful to understand cultures. So for example, in some cultures, you will never agree to be disconnected. The person, once they're connected, they have to be allowed to die. And some, so for example, Ariel Sharon, a former prime minister of Israel, he had a stroke and he was connected to equipment. And then everyone says, well, sorry, you can't disconnect him. He's an Orthodox Jew. He has to be allowed to die naturally. You can't disconnect him. So it was 8 years that he was connected. And Mr. Rasouli is still connected. So more than 8 years have passed and he's still connected. At least that's the information that I have. Now, if you're Catholic, for example, you can decide it's futile. We can disconnect, and there is no moral wrong committed in disconnecting someone. The withdrawal of a treatment is a legitimate act when trying to keep someone alive is futile. And then you've got other religions to look at. I'll give some other examples later. So that was an example where like withdrawal is not one of the points specifically listed here, but it is an other health-related purpose that is being addressed. In 2016, I mentioned MAID here because MAID is also a treatment and it's not specifically listed. The Supreme Court of Canada in 2016 determined that medical assistance with dying is a treatment. And that meant in Ontario that the Healthcare Consent Act applies with respect to capacity and consent. And also the Supreme Court put some limits there, and those limits are being studied by Parliament now. And the limit there was on whether you could make an advance request for medical assistance in dying. Because normally you can't do that, and I'll get into the point about wishes later, but normally consent is specific to circumstances. They're not abstract decisions. I won't say more about medical assistance in dying. OSPN has some very well-versed people in that subject. And I wouldn't be surprised if there will be some presentations made when Parliament issues its recommendations on this subject. So we can go to the next slide. So health and personal care treatments require consent. So this is where we're getting into the details of the law and where I've tried to synthesize things. So consent by the patient or by a legitimate substitute decision maker. So the next bullet, every incapable person has an SDM. Like if you are determined to be incapable, someone has to be found to stand in and take the decisions on your behalf. We'll come to the listing of the types of people who can be substitute decision makers. If a patient is deemed incapable, it's the care provider who is supposed to find substitute decision makers' consent to any treatment. Now, an exception is in emergency circumstances. So in emergency circumstances, the healthcare professionals will do what they can to keep the person alive, stabilize the situation until they can get substitute decision makers to come in and say what they want. So for example, one fellow that I knew 20 years ago, I'd seen him at lunch. There was a luncheon group we used to meet, and I'd seen him and I didn't think he looked very well. And sure enough, he had a stroke or a heart attack, I think a heart attack that afternoon. And he could have gone, but the son who was had power of attorney, the substitute decision maker, said, keep him alive no matter what. And that they did that for 6 months. And the purpose was so that the family could come to terms with their feelings about their father. And you can say what you want about that. We all, I think, will have reactions to that. The patient, when he was able to communicate, told a friend who visited, why can't they just disconnect me? But it was the family who wanted to keep him alive while they worked out their feelings about him. So that's their searches, circumstances like that need to be taken into account. So if a patient is incapable, it's the substitute decision maker who takes the decisions. And these are based on, there are two broad categories of criteria. So first is the patient's prior expressed capable wishes about care and quality of life applicable in the circumstances they're in now. So let's parse that a bit. So prior expressed capable wishes. So these are wishes applicable to the circumstances they're in now, okay? So they're not in some abstract sense. They are, the person was really saying, okay, if I'm ever in this situation, this is what I want you to do. And they were capable at the time, so mentally competent at the time that they expressed those wishes. And they expressed those wishes. It wasn't just, well, we think they would have liked this. Rather, they actually had to have expressed it. And all of this prior to finding themselves in that circumstance that they're in now. If there are no prior expressed capable wishes applicable, then the SDM is to take decisions based on the patient's best interests. And so the best interests are gauged in terms of the person's, Rick, you're trying to say something?
I just wanted to know, Dan, are you going to talk about, you're talking about consent. So are you going to talk about the fact that it's the consent that becomes the difficult part in some ways because they're not capable, they're deemed incapable, but that doesn't take away their ability to have consent. Just the way you're saying it right now sounds almost as if I get deemed as being incapable, I have no ability to participate in my consent and care. So
what? So we'll get into this more.
Okay, that's fine. Okay,
But,
thank you.
but at this level, so we'll go deeper into the details, but at this level, thank you for asking though. Like at this level, basically, if you are deemed incapable, and without all the qualifiers that could apply, then you turn to the substitute decision maker. Okay, so when there are no prior express capable wishes, the SDM is to base their decisions on what they consider the patient's best interest based on known values and beliefs, wishes that they made that could be relevant, as well as benefits versus burdens, the sorts of options. If they're given options for treatment, what is going to have, like, will they ever be able to walk again? Will they be able to talk again? What circumstance will there be in? There was one case, for example, a man, like, to answer, give an example specifically relevant to Rick's point. So here's a man who is deemed not capable of everything, but you want to still engage him as much as possible in the decisions that affect him. And so he was asked, you know, like, he's got cancer, he's been operated, he's going through chemo, he's very impaired now. And the daughter was wondering what he wants. And she's a registered nurse. She's familiar with all kinds of stuff, and they've had intimate conversations. And he said, as long as I can watch my football games and eat ice cream, I'm good. And she was surprised, but that was what was happy for him. So that was the choice that so you have those kinds of things. And that was based on where he was at that moment in time. The last bullet is consent must relate to the specific treatment decision. So basically I said that kind of thing. So it needs to be informed. Like, you can't ask someone to take a decision without explaining to them what it is that you're proposing to do and what the pros and cons are, what the consequences could be. You need to let a person know what the issues and options are, and they need to act freely. It needs to be a voluntary decision. They're not to be coerced into it. You can't trick people into it. You can't misrepresent the facts. You have to be honest with people. Now, I'll mention here, my own personal experiences as substitute decision maker for my oldest brother. Because even though you think you've discussed all kinds of things, you can be surprised. So my brother, his wife died in 2010 after a 5-year struggle with cancer. And towards the end of her life, like the last months, she said, you know, if it was going to be like this, I wouldn't have bothered with the operation 5 years ago. But the doctor had said it's a cancerous lymph node in the heart. Normally we don't operate those, but otherwise you're healthy. So he recommended surgery. She survived the surgery, but the chemo almost killed her. Then you go through 5 years, she gradually is getting her strength back, and they do one of those big tests just before determining whether you're clean. And they say, you know, everything looks good. There are just 2 little spots up in your head. We don't know if they mean anything. And that was in mid-February. In mid-April, she was in excruciating pain. They determined that she had brain tumors. And in mid-June, she was dead. So it was in that period where she said, if I'd known this was going to happen, I wouldn't have bothered with the initial operation. And my brother took that, I'm not getting operated. If they tell me I've got cancer, I'm not getting operated. And so in 2017, he was diagnosed with cancer. And I thought he's going to say no operation. Instead, he surprised me and he wants to be operated. Okay, so we go through that process. And, but he refused to have chemo. And this year in December, so let's see, that was just over 4 years from his prior surgery, he was diagnosed with cancer again. And at first I was told, this is terminal. We don't know how long your brother has. And I asked them to tell my brother. I said, I want him to hear this rather than me being the one taking a decision without discussing this with David. And David said he wanted to be operated, even though they said he was terminal. So again, I was surprised, but they examined the tumor that they removed from his spinal cord and determined it was not the same cancer that he had had 4 years previously. In fact, this one came from his prostate, and prostate cancer is much easier to treat. So maybe he has a good number of miles ahead of him still, but he does have a lot of tumors throughout his body, which they're saying can be treated with hormone suppressants. So you suppress the testosterone and in the vast majority of cases now, they can prevent that from being what kills you. Die of something else is what the doctor said. So we'll just have to see how that goes. Another point, though, I want to make before I leave this page is do not resuscitate. You know how we're asked to do advanced care planning, and a lot of us will say, do not resuscitate. So you have that in your documents when you go to be operated on. And I'm with my brother when he's going for his surgery in 2017. And I point out to the person at the desk that's we're dealing with that David does not want to be resuscitated if if his heart stops functioning while he's in the operating room. And the lady says, you'll have to discuss that at the next desk. Okay, so we discuss it at the next desk. In fact, there are several desks, and it's basically a half day that we're going from one desk to the other before we get to the operating room. And each one puts us off to the next. And finally, the last desk says you'll have to discuss that with the surgeon. So we're in the antechamber of the operating room when the surgeon comes to meet with David before he gets rolled in. And I said, David says he doesn't want to be resuscitated if his heart stops. And the surgeon says, in the operating room, a do not resuscitate order doesn't apply. So why do you have a do not resuscitate order? Well, it doesn't apply because so many people, when they're being operated, their heart stops. And if we let every one of them die, then we'd lose an awful lot of people who we can save. But the concern with DNR is that if they're doing a resuscitation, cardiopulmonary resuscitation requires a lot of pressure. And very often the patient's ribs are broken. And this makes it very hard to recover afterwards. And a lot of people go through depression, and you think they die more of the depression than because of the actual operation that they had. So what the surgeon said, and so I knew that part already, and the doctor, he said, so if your brother's heart stops, I'll ask the 320-pound sumo wrestler not to press very hard on his chest. Okay, so he tried to make light. As it turned out, my brother's heart didn't stop. So it was a non-issue. But those are the kinds of things that I think people want to know about, that, and they don't know that DNR doesn't apply in the operating room. So let's go to the next slide. So only a capable person can give consent. And that's by law, everyone is presumed to be capable of giving consent. Okay? You have to be proven to be incapable. And so if there's a doubt as to someone's capacity, it's the person who is proposing the treatment who makes the assessment. Now, unfortunately, watch this carefully, because this is a tricky moment. So very often you will see that the doctor or nurse or whoever is going to propose some treatment, and the patient says, well, I'm not comfortable with that. I don't like that idea. And very often at that point, the healthcare professional will say, well, he's not really capable of taking that decision. I want to ask the substitute decision maker. I get asked this sort of thing very often. And I reached the conclusion, and I then confirmed it with doctors, that basically, if you agree with the doctor, they will agree that you are capable. But if you disagree what they're recommending, very often you will be deemed incapable. Okay, so watch that moment. And so then if you're not able to sort that issue out, that can get referred to the consent and capacity board so that they could determine that the patient is incapable, or they can even have the substitute decision maker deemed incapable. So the third bullet there, capacity may fluctuate with time. It also depends on the particular decision. A person may be deemed capable for some decisions, but not for others. So for example, my brother, basically he's in long-term care because he suffered some mini strokes, so some cognitive impairment that largely affect his executive, what do they call it? Executive decision-making function, something like that. It's basically your decision-making functions. But it's really about his personal care, his day-to-day kind of care, I find, where he has trouble dealing with things. I find that when he's faced with these bigger issues with the doctors, he's been really on the ball. Now, maybe that's because he's been in long-term care now for 7 years. And I asked a psychiatrist that I know, like with neurology, they talk about neuroplasticity of the brain and how the brain can repair itself. And I asked, is it possible that his brain has been repairing itself? Because frankly, I think he's more with it than he was 7 years ago. And this psychiatrist, he said it's possible. But, so I'm still very much involved in care decisions, but like the circumstances can fluctuate. So in this case, I think maybe he's got better, but a lot of people, let's face it, are going to be getting worse. Like dementia can get worse. And there are so many different types of dementia, like mini strokes are cardiovascular events. And so they can happen, and you can go like from one day to the next, from being really very clear and capable to suddenly being quite impaired. Anyway, so that's an example. For me, my editorial comment on this slide is that there's a major interplay between patient autonomy and agency on the one hand, and care providers' beneficence and paternalism on the other hand. So there are these palliative care conferences that I've participated in, and they've had those as themes for the day or the evening, where they talk about trying to strike the right balance between patient autonomy and paternalism. Here's a case, here's an example. Or even I'll give you 3 examples. So 2 of them involve Supreme Court decisions. One, there was a lady, Jehovah's Witness, who was in a car accident and is seriously injured. And she's taken to the hospital. They see in her papers that she's Jehovah's Witness and does not want to be given any blood transfusions if ever that's called for. But at the hospital, the doctors determine, no, she needs blood transfusion in order to save her life. And she survives with the blood transfusion. She recovers, and she then sues the hospital for having subjected her to a blood transfusion. It's well known that Jehovah's Witnesses are opposed to blood transfusions. And the Supreme Court, eventually the decision works its way through the courts to the Supreme Court, and they determined, no, they needed to respect her wishes. And so then she was able to sue the hospital for compensation. There was another case where a man was in an institution with psychotic incidences and delusional thinking. And in the institution, they wanted to give him antipsychotics, and he was opposed. And he was able to get somebody to represent him and taking this to court, and it made its way to the Supreme Court. And the Supreme Court agreed that he was sufficiently capable in these instances to determine that he did not want to be given antipsychotics to reduce this delusional thinking, even though he was taking decisions that were perhaps not in his long-term best interest. Those were decisions he had the right to make. Here's another case that I knew in Ottawa, or heard about in Ottawa. It didn't go to court. There was a man who was dying in the palliative care wing of a hospital here in Ottawa. And his partner wanted him to die at home. The hospital, she told the hospital staff that she wanted him to be taken home. And the hospital staff were concerned because the lady, the partner, she had major mental health issues herself, addictions, and she wasn't reliable in coming for meetings when they scheduled them, and they wondered whether she would be capable of providing the care he needed at home. Because you can try to arrange in-home care, but they're not there 24 hours, and these were not people who would be able to afford 24-hour care. So the staff were really very concerned about what the husband would be experiencing as he was dying. They arranged for someone, I think a social worker, to go with the wife to check out the home, and they determined it needs major retrofitting. Like he would need to be in a wheelchair to get from the bed to the washroom. You can't get a wheelchair through that door. You need to, knock out part of the wall. You need, what do they call them, bars on the wall so that he can get into the shower, which was in the bathtub. And there were things like that, but lots of issues. And they were really concerned, and yet the spouse was insisting, I want him at home. And everyone was so relieved when the gentleman died, because that meant that, okay, that's, so he's died and he's had the care that he could get in the hospital. He didn't die at home, where he wouldn't have been able to get the care he needed that quickly. Like, it takes time to arrange for someone to come in and do that kind of work. So those were a few examples. Next slide, please. The test for capacity. I've got two slides. This is like first cut at it. So test for capacity to consent to treatment. Now, there are medical and legal standards that exist that get more and more detailed, and we're not going to go into those, but I want to give you the basic principles. So a person is capable with respect to a treatment if the person is able to do two things, both of them they have to do. Understand the information that is relevant to making a decision about the treatment, the specific treatment, and secondly, able to appreciate the reasonably foreseeable consequences of such decision or lack of decision. So let's go to the next slide for more details. So I was able to find somewhere in the literature online a few examples of what's meant here under understanding information and appreciating the consequences. So if we look in the left-hand column first, 3 examples for illustration. So understand information. First example, can they remember information long enough to come to a decision? Like that's a very practical issue. Like people often are no longer at the end of life or no longer able to remember everything that they hear, even if it's about them specifically. And then are they able to process the information relating to risks, benefits, and alternatives? So you see, it's getting to be complex information. And here's a specific example, but it's a rather light one, I would say, in terms of the range of possibilities that occur in real life. Can the person understand that if they put their name on a waiting list for a long-term care home, their name may come up? Like that sounds pretty innocent, but often that even can be a challenge. Like, oh, like give me a piece of paper and I'll sign it. But do you understand the consequences? That if you sign it, your name comes up. Okay, what are you going to do then? So next column here, the ability to appreciate the reasonably foreseeable consequences of giving or refusing consent. So by appreciate, what they really mean is, what does it mean for them? Can the person assess, evaluate the information in terms of what it means for them in the circumstances they are in right now? So can they assess how the proposed treatment options and plans might affect them? So for example, here's a more dramatic case, but one that was apparently quite common during the pandemic. You're having trouble getting oxygen in your lungs. Should you be given a tracheotomy? So an incision in your throat with a tube to put air in the lung, or a ventilator, which is another way of getting air into the lungs. And I don't know all the differences at all, but imagine somebody who's very sick being able to deal with that kind of issue. So you have to have a decision maker who can make that kind of decision. Can they acknowledge that the recommended treatment may affect their interests? Well, what might those interests be in a choice of long-term care home, for example? With my brother, he was first in the hospital, and as it happens in most cases, it's usually an emergency that ends up putting a person in long-term care. So he was hospitalized, and while he was there, I was appointed substitute decision maker, a sister and I were, and then he needs to be in long-term care. There was nothing initially available. So do we agree to him staying in the hospital, but being at what they call an alternative level of care, which means that we pay for him to be there? Okay, we agree. So that's a conscious decision that costs money. Then a bed comes up in a place and they put him there. And we wondered, well, this is a big old establishment, 400 beds and all that, is that a good place for him? And so when we went to see it, we also checked out some other places. And for example, there was one place that was brand new and it was absolutely dead. Our brother is very sociable. And actually being in a big place worked out well for him, because he could find enough people in there to socialize with. So that was one plus. Another thing was where he was located. He was close to a big park down by the river. So just, and he's free to roam. So he was able to go down to the river in one direction, like to the west of the long-term care, like a 15-minute walk, nice park down there, and he can go fishing down there. He could also walk to the center of town. There's another nice park where there's all kinds of entertainment, and there are bars and restaurants, and he's got pocket money. So those sorts of things he's great for, but when it comes to care decisions, just can't handle it. So in the end, we decided that's actually a good location for him to be in. And frankly, I wish we had something located like that. The closest we've got is Bruyere, Elizabeth Bruyere residence, but it's not really the same sort of situation. So Can the person acknowledge that if the name comes up, they would have to move? Do they appreciate what it means for them if they do not accept the long-term care bed? Like a lot of people, they figure, well, they'll give me the next bed then. If I refuse this one, they'll give me the next. Well, apparently nowadays you're put at the bottom of the list, right, Rick? Yeah. And so, and like there are huge long lists to get into long-term care. And so you're asked to indicate your preferences, but very rarely do you get where you would prefer to be. You end up where they've got a bed for you. Thank you. Next slide. So into the substitute decision makers, two different types, two different bodies of law, if you will. Before you're ever declared incapable, you do want to appoint someone who can act for you. Because if you're going to appoint someone, it needs to be put in writing. And that's what a power of attorney is about. And you can only put it in writing if you are capable. It's under the Substitute Decision Act that powers of attorney are created. And power of attorney, POAs, we often hear that term used in reference to a person. Like I'll say, I'm my brother's POA, or an SDM, I'll say, depending on who it is. So, because a lot of people don't know SDM, substitute decision maker, but they know the term POA. But POA actually applies to the written instrument that gives people the power to act for others. And that's what's meant by power of attorney. An attorney can act for another person. So that's the SDA. Under the HCCA, you have a hierarchy of substitute decision makers for healthcare. And these include court-appointed and automatic SDMs if the person has not been appointed through a written POA for personal care. So let's go to the next slide and look at that hierarchy. Are you, Maddie, are you there? Good, thank you. So you see there are 9 different types of SDMs, substitute decision makers. Whereas under the Substitute Decisions Act, you've got either court-appointed decision makers, substitute decision makers, or people who are acting under a power of attorney. So the first 3, let's look at those. Those are legally appointed SDMs. In the first case, a guardian of the person with authority for health decisions, this is a court-appointed person. Second, this is attorney for personal care, and this is the person with the POA for personal care appointed by the person who had not yet become incapable. So that's considered legally appointed, but that's not court appointed. And the third is appointed by the Consent and Capacity Board, which is almost like being appointed by a court, but it ranks lower in the hierarchy. The first, as I understand it, the court-appointed guardian is if the person with power of attorney becomes incapable. So first, the patient has become incapable, but there's the substitute decision maker with power of attorney who can act for the patient, can take decisions. But then, hey, something happens and they're no longer capable. What do? They can't appoint someone for themselves. See, that's part of the problem. You can't then delegate that further, but you can through the court. You have to go through the court to have that done. So if we look then at numbers 4 through 8, that's 5 automatic family member SDMs. These are ones, they're automatic, they're not appointed pursuant to written powers of attorney. And you see there's a hierarchy. So a spouse should rank higher than a child or a parent or the Children's Aid Society, if that's the situation we're dealing with. Parent vis-a-vis a child, well, does that parent have the right of access? Like when families break up, sometimes one parent will not be given the right of access to the children. Brother or sister, well, they, like I'm a brother to David, and I arranged with with a social worker to get my brother into the hospital. And then I arranged for my brother's lawyer to see my brother in the hospital. And David agreed to appoint me and one of our sisters as give us power of attorney. And then any other relatives. So for example, a lot of people end up with nephews, like especially in the LGBTQ community, often our relationships with parents and siblings are strained. And but sometimes we have better relationships with nieces and nephews. So they would fall in that range. And some of us, like I'm a gay grandfather, will my grandchildren perhaps be the ones who would be acting on my behalf when I'm 95 and they're in their 30s, for example, that sort of, who knows? And the last, number 9, this is last resort. So the office of the public guardian and trustee, this is a court appointment. So someone who has been appointed by the court. And one comment on these hierarchies, even if you've been appointed, you may very well be dealing with other family members who also have views onto what is the appropriate care. And so disagreements often arise. And sometimes those things have to be sorted out in the consent capacity board. Just a second, Rick, I'll get to you. And but what you try to do, I'll come to in 2 more slides, how you should try to deal with that. But you want to try and talk as much as possible among family. And like there are actually people, some hospitals, like in Toronto, my understanding is some Toronto hospitals actually have people on staff who can facilitate difficult conversations among family members concerning their loved one's care. Sometimes you have to hire someone, but those can be very valuable assets. Rick?
I was just going to ask Dan, are you going to clarify the role of PG&T in that PG&T takes no responsibility for personal care? So if your statement is a suggestion that a substitute decision maker in a healthcare act is such that PG&T takes that responsibility, they don't. PG&T only take responsibility for their financial care, and when it comes to personal care processes, they defer always to the care team or the doctor. So as in the case of, I prefer to have no treatment given. I then get a PG&T. PG&T say give full treatment. Right up to you're 106. Friggin' put a tube feed in and keep that person alive. That's the role of PG&T. Their role is to intervene in the cases of finances to make sure that payments made. But other than that, when it comes to care, PG&T do not make care decisions. They leave it to the so although it's on a strata in that it goes down to PG&T, it's a default more than an award, if that makes sense to people.
Well, I take what you're saying to mean then that it's almost a misnomer for them to be in a healthcare consent act if they're not able to take decisions related to healthcare.
You're absolutely right. And I was just clarifying that.
I was not aware of that. Thank you. As this is not my field. I'm trying to help. You're
doing a good job. Doing a good job.
Thank you.
PG&T is not a savior. That's all I'm saying. So on your list of 9, you've got 8 before that. Hopefully the families won't squabble. PG&T comes in when they squabble.
Yeah. See, I'm familiar with G&T, but not PG&T.
Right, public guardian and trustee.
Gin and tonic. Okay. In moderation, of course. But,
And see, I don't drink, so I didn't even get it.
okay, all right. So let's go to the next slide then. So the criteria for a substitute decision maker, and I'll give you a few little examples concerning me. So first is the substitute decision maker has to be willing to take on this job. There is actually an awful lot of work involved in this. And second, they need to be available. Third, they need to be capable. So, and for that bullet, like capable with respect to the proposed treatment, you really want to find someone who will be capable when your time comes. You don't want to appoint someone who, well, he's my best friend and he's 10 years older and I'm 70, and like, is he really going to be capable of being there and acting for you? That's where it gets dicey, really. The last two bullets don't apply to us too much, but I'm going to give an example. So like a friend of mine, I knew her husband well, but when she was dying, and this was 2015, and I'm dealing with my brother's stuff. I'm having to liquidate all his affairs after he's been hospitalized and then moved into long-term care. And I'm spending 10 to 15 days a month down in his town, handling things. And this lady friend, she's dying, and the husband asks if I would be willing to be his POA for financial and personal care. And I replied, I need this like I need another hole in the head. I took that as a no. I said that as a no. He took that as a yes. And I didn't know this until the next year. I will around in May, because of my brother's birthday, I'll typically take him for about 10 days to visit friends and family. So 10, 12 days. And so I come back from this trip and I was checking emails and voice messages from time to time, but not regularly. And when I got home though, I checked my voice messages and there's a whole bunch of phone calls. So this fellow who I thought I had declined as power of attorney, he had called from New York to say that he'd been down there for a university reunion and he'd had some mini stroke that had left him impaired, but not too impaired that he could not remember my name, find my telephone number, and leave a message asking me to fly down to New York to bring him back to Ottawa. And there's no indication when he had left that message. So then I checked these other messages and it's friends of his who are assuming that I'll be doing it and taking care of him. And they're all sort of gung-ho that I will be taking care of him. Then I'm checking my emails and one guy is emailing the son who lives out in BC and saying, oh, don't worry, Dan's going to take care of it. And so, hey, I'm in a difficult situation, but I can't do everything. So I called Bill and turned out, I called him on his cell phone. He was already back in Ottawa. And I told him, listen, I can't handle your circumstances. You have to find somebody else. I thought you'd already found somebody else since we hadn't talked anymore about this. So you can get people like that. And there was a lady who asked me once, she said, I'd like to name so-and-so as my power of attorney, but she doesn't want to be. So can I just appoint her and then she'll have to be, because I can have the lawyer tell her, like if ever I'm in a bad circumstance, the lawyer could call her and say, you are the power of attorney. And I said, you can't do that to a person. This was before studying the law. But you see, people will think, well, hey, I can get them to do it. They don't want to. And so that's what Bill was trying to do with me. And he had tried to bully me, in fact, into it as well. But you have to, like, what can you capably do and responsibly do? And you still have to be able to take care of yourself at the same time. So, last slide. So if there are disagreements that can't be resolved by the local remedies, I call them local remedies, and that's a misnomer, you go to the Consent and Capacity Board. So I use local remedies. In international law, that's what you talk about. What I meant really is like in-house remedies. So for example, the hospital or a long-term care home should have a complaints procedure if you're not happy with what they're proposing in terms of consent for a treatment. And Rick, I'm looking at you, hoping you can fill in since you have so much experience in this field. But basically, try to work through the established procedures in the hospital or long-term care home first, then escalate them, but also you can try to have a mediator facilitate conversations. If you're having difficulty, like the substitute decision maker, let's say it's me, and the doctor wants to do something and he doesn't agree with me supporting my brother's reluctance to go along with the particular procedure, or prescribing some drugs, for example. Because we tend to try to avoid meds in our family as much as possible, what is reasonably possible. Sometimes you can't avoid meds, but sometimes, like our mother basically was over-medicated once she was put in long-term care, and she, or even before, like she suddenly lost her coordination. And after she died, we figured she was on a lot of anticholinergics, which impair cognition and coordination. We didn't know about this until after she died. But she went from being 83 and physically active, going around independently, visiting friends and shopping and everything, to having falls. And so then they say, oh, well, she needs to be in long-term care. And I asked for an MRI scan. That was done. And they said, well, her brain is aging normally. Well, so then why is she having these falls? And the answer from the doctor is, she's where she needs to be. End of the discussion. And we accepted that. We didn't know that we could have pushed further. We could have reviewed the meds and perhaps got some changes to the meds. So the Consent and Capacity Board adjudicates disagreements over capacity and consent under the HCCA, SDA, and 4 other acts. It's a quasi-judicial body at arm's length from the Ontario Ministry of Health. And if you don't like, or if one party or the other doesn't like the decision of the CCB, then they can appeal to the courts, and if necessary, all the way to the Supreme Court. So that's the presentation. Yeah, Rick.
So what I'd like to add, Dan, is that, well done. This is very, very tricky and very gray. And so that's why I was like, don't think this is the answer, or don't think that. And so what I would say to anybody who wants to see this or learn anything, and that is, pick your POA with the utmost care. More so even than when you friggin' get married. You can divorce someone when you get married and you realize you made a mistake, but you are incapable by the time you realize your POA is up and just wants to hurt you. And they do. I've had many POAs who really just hated their mother so much. When they moved into care, they refused to allow us to give analgesics for pain. And so mother lived, because she was holistic her whole life, that the daughter thought that was the kind of thing that she would want to, this woman died a horrible death, absolutely terrible. because the POA had the power to say, no, this is what mom would have wanted. So we went to the Passing Consent Board. It took too long. She was dead before we went through. So I would say if there was one thing that you really want to stress, it is power of care. Power of money will be fought in the courts anyway. So I always tell people, don't worry so much about being power of finance. That can go to PG&T without difficulty. But power for care determines whether or not your agony is prolonged or whether your relief is forthcoming. So if there was one thing that I would say in all of this, it would be pick your POA with the utmost care. Don't pick the richest, don't pick the oldest, pick the one who will stand up for you, for what you want. And that I think is, and if you had grandchildren, it'd be perfect because they'd be right at the right age. But this is a really difficult process for people to get around, the idea of consent. And consent is also the last thing, isn't just a simple black and white. You don't flick a switch and someone doesn't have consent anymore. And Dan, your examples were right on with your family, examples that are true where you go, I know the person, but still I need to ask them. And that's absolutely true. So no, it was well done. Thank you.
Thank you. Thank you. Any other questions or comments? If not, we can wrap this up and we can stop the recording.
The only comment, Dan, I appreciate your examples. I found that they illustrated your points very well, and they gave a good sense of how each applied to how each example applied to the point. So thank you for finding those exact examples.
It's half of them were lived experiences.
But I think that's what makes it so much more powerful too, right?
Yeah.
That it's interesting to have the Supreme Court examples because they give validity to the point you're making in a legal way. But the lived ones, I think, reach back to what Rick is saying, right? That there's a real impact in terms of how things are lived on the ground, not just, in sort of the more office theoretical lawyers, it's really when you're faced with the situation, how do you respond? And I find that the balance between your examples was very good. Thank you very much.
Thank you. Like for me,
anybody have anything else? Yep.
For me, I'm trying to help humanize the healthcare system, and it is really a very complex system with lots of laws and everything, and it's by bringing together the lived experiences with the laws that I think we can try to make sure the laws respect our frailty and our human needs.
Well, to use a personal example, so I did the presentation last time about some of these issues, right? Because I had gone through the document that I highlighted. So I learned about the difference between the power of care and the power of property and financial. And then I pushed my mother. My mother went from where she resides here in Ontario to Montreal, where she has an apartment. And before she left, I said, if you were ever to get COVID, she has COPD. I said, we need to have a document. So she pulls out her file. She's telling me she has her DNR. And we were told when my father went into the hospital repeatedly that if he didn't have his DNR on him, not in his file, literally on him, like on his person, not in his room, but on his person, who carries a DNR every day, all the time. Anyway. So at 2 a.m, we had to have the DNR, which we couldn't find. So they're like, sorry. We get to the hospital, the DNR is nowhere to be found on his person, right? So they're like, sorry. So finally, after repeated hospitalizations, they put a DNR in his file at the hospital. Still, the ambulance attendants every time would be like, sorry. So by the time he got to the hospital, we knew we were covered, but we knew they would keep him alive to the hospital if anything happened. That never materialized, but nevertheless. So I told my mother, where's your DNR? Because they had them done at the same time, the two of them. She's like, oh, it's in my file. I said, but there's no point to that. We can't do anything because it's in your file. It's not in the hospital. It's not on your person. There's no point. The DNR, we never found it before she went to Montreal a couple of weeks ago. But she does pull out, and it turned out that we had signed power of care and power of property and financial, and I'm the main character. I'm the main person on it. She added my sister. Meanwhile, I am not the most financially responsible of the whole 4 kids, and I know that she counts on my brother to do so. My brother is like the 3rd or 4th person on it. So she wants to redo all her paperwork. I'm like, just do not rip these up before you do the other ones up, because we have to get them witnessed and the whole bit. So it turns out that the whole time we had actually done this. She didn't know. I didn't know. I didn't realize that that is what we had signed a couple of years ago at the time of my dad's process. So we actually had all these documents, not understanding exactly what we had put in place. So Rick, I think that what you were saying was very valid, is that many of us make decisions based on hearsay or what we have been told, power of attorney. We have no understanding of what really that involved. And I think that is what I'm really appreciative of with what we're doing in this committee, is that I am not just learning in terms of, community and how it affects the LGBTQ community in general. I'm really appreciating that it helps me in my day-to-day life and in my family life, because this is something that my mom's fairly healthy considering, but COVID has proven to us that in, 3 days, you can be in a situation where you need to put this into application. So I really appreciate Nip.
To be honest, a DNR isn't worth the paper it's written on. And I know that sounds awful, but it's truly not. It gets overridden by every ambulance attendant, by every physician, by every medical intervention. A DNR is really just a way to tell people that if you have an opportunity, don't go out and do heroics. And so that in long-term care, that's how we viewed it. But I can tell you, within the acute care sector, a DNR is a waiting litigation, and so you can. It's pretty hard to win a case when you're alive. You know what I mean? So yeah, but DNR is very different than substitute decision makers and POAs, and you're absolutely right. It all gets rolled into this whole process. And for 15 years, I did work in the field, not knowing until I'd walked through each one of the situations, realizing just how important it was. But a DNR, not so much, not anymore.
More so, I will add to that. Okay, so we have all this stuff done for my dad. Okay, he goes into hospital on a Friday because he's not very clear. We think he's a little too foggy. So he goes in on a Friday. Monday morning, he speaks to my mother. Saturday, Sunday, he's still a little foggy. And on the Monday morning, we get a call. He's just undergone respiratory seizure, like he's just stopped breathing. And they were wondering what to do. My mother starts asking questions, and so they're wondering, they're keeping him alive with oxygen, but they're like, what do we do? Because basically, and they're trying to make it clear to her that he's basically dead. And my mother lives in denial, so in everyday life. So in this case, she's even more in denial. And she says, well, yeah, we'll make it to the hospital, my daughter and I. Please keep him, yes, intubate him. Now, my dad has asked for a DNR, right? So the reason she wanted him intubated was so my siblings could come from Montreal to say goodbye. This is in COVID time, guys, okay? So we're not even sure we get into the hospital. He's now being brought to ICU, which they knew him very well because he'd been there repeatedly throughout the year. And so they see him come down. My mother and I arrive, and they're trying to make it very clear that they have tested him for the ability to breathe on his own, and they have confirmed that he cannot. So he's basically dead. And my mother is still hoping that when they stop, he might start breathing again. And they prove it to her in front of her. Okay, so they stop the machine. They show that he's not picking up his breathing. And she's like, no, but my children are coming from Montreal. So basically, she went against my dad's wishes just so that my brothers could say goodbye to him. And so to me, that was sort of it didn't matter that he had a DNR because my mother, the SDM, asked for him to be kept alive. So to me, that was the example of how the DNR just gets thrown out the window in a second flat if the SDM makes a different decision. And so I agree with you, Rick. I'm seeing this more and more, is that the power of care is so much more critical. And yes, the power of finances gets tracked super easily, but the power of care in terms of clothing, pronouns, these kinds of things, just, I mean, right now, I have a friend who has a friend in Calgary, and his daughter is on a different planet than he is. They're vegan, him and his partner, they're vegan. The daughter doesn't even want her children going to the grandparents because they're going to be fed vegan stuff, and she's all into boxes and crap food, and she wants the children to be able to eat what they want, but the grandparents won't want. I said, you better watch out, because if she becomes his power of care, they're in an accident or something like that, and his spouse can't do it for him because she passes or something. He's dead meat, because this daughter is not going to respect anything he wants. I said, he better be careful, because she's the next in line. So
No
anyway,
meat.
I've learned a lot.
No meat. They're vegan. They're vegans. There's no meat.
Sorry, guys, I have to interrupt, but I have to get to another Zoom meeting. But thank you. The presentation was great, and I learned a lot. So thank you.
Thank you so much for your help, Maddie.
Bye.
So
Could I ask you, Natalie, a question following up your family example, though? Because it sounds like your mother appointed 4 or 5 members of the family in her power of attorney list.
well, on the documents that we filled out, there's a line, and it says person or persons. So she put my name. My sister didn't like that. My sister said, that's not okay if it's just Natalie. What if we're in Montreal and something happens to you? Okay, so she added my sister's name. Lower in the form, just the next point, they say, now if these people are not available, do you have other substitute people? She put in my 2 brothers' names.
Okay.
So it turns out that she's got, so at this point I said, okay, well, you might want to watch this or rejig this. This is based on if they're here with me.
Yeah.
But if they're in Montreal with my siblings, let's say she was in an accident or she had COVID there, then I'm not as much in a position. I mean, I have to go to Montreal to be around her, whereas my 3 siblings are there. So we're trying to play this. I said, okay, well, what if we were all 4 so that there's no argument, or all 4 of us can make decisions? My sister didn't like that too much. Said, that might create more tension than less. I said, look, I don't really care. And this was for both of them, the power of care and the financial one.
Right.
So now I suggested, okay, how about we make it so the girls were the power of care and the 2 boys are the financial side. However,
Questions,
I don't
Lou?
want.
Question. Did your mother appoint you jointly and severally, or only jointly?
Yep.
Jointly and severally. Okay, so
Yeah,
you
yeah,
can
separately.
act independently as well.
Yeah, we made it so that, because I said, I don't want to have to be stuck in the hospital calling 3 other people to get one decision. Tell me what you want, and I will respect that.
Yeah.
So that's what I had, but I don't want my siblings to come after me and say, well, you made these decisions on your own.
Yeah.
It was okay for my mother to make those decisions for my father, like revoke his DNR in a sense. But for me to make those decisions, I'm the black sheep in my family in a sense. So I'm pretty sure that those decisions will be easy to contest by my siblings, my 2 brothers in particular. So that's what I'm trying to protect myself from, in a sense. And, when it comes to care, I know that I will respect my mother's wishes, and they will respect that. It's when it comes to the finances that I think that it will become trickier in our case. So I've seen enough. I taught adults, and I asked tons of questions of how their family dynamics went, because most of my students were older than me at the time. I see this coming down the pipe, and I'm pretty sure we're going to have some kind of conflict upon my mom's death. So I'm trying to head this off. And if we can have at least a decent process till death, then that's one thing. And then afterwards we'll deal. That's about, us as adults, not us as children. So my goal is just that we get to my mother's death in a way that respects her as a person. And that's what I'm aiming for. So I want us to all be able to work together so that we do this. And having gone through this with my father, I was first row, right? I was right there with them. So as opposed to my siblings who were in Montreal. So I know what's coming down the line. And I mean, my mom's healthy and she's 81. So 82. 81. I don't foresee immediate problems if she doesn't catch COVID. So I'm just like, we're at the end. Come on, Mom, hold on. But anyway, so that's my story. So nothing's happened, but having seen friends go through this recently with a mother-in-law who dropped into their lap from Quebec to Ontario, the opposite, without care papers, expired medical card, medication that's from another province, being hospitalized in Ontario, then being hospitalized in Quebec, then Ontario again, then Quebec again, then trying to put her on a plate. It was just, and no paperwork. So they went through this, and then there's 3 or 4 kids. And anyway, so I'm just trying to, see this coming. And I really appreciate Rick, Dan, I appreciate your experiences, and Michelle too, with everything that you guys bring as experience and as knowledge. So thank you very much, all of you guys. I see time going by. It's 11:24. Thank you very much, Dan. I think that was a great presentation. Does anybody else have anything to say? And then maybe we can stop the recording.